Most real estate agents think their liability ends the day the commission check clears. In probate, that assumption can destroy an attorney's practice. An heir can challenge a fiduciary decision 3, 5, or even 7 years after the estate closes. And if you recommend the contractor, approved the repair cost, or managed the property cleanout, the attorney will look to you for the documentation that defends their decision. If your defense is a folder of scattered emails and text message screenshots, you've not just failed the estate, you've left the attorney legally exposed. Today, we're building the Un-Sueable file. In aerospace, we had a rule. If it's not documented, it didn't happen. In probate, the standard is even higher. If it's not documented with proper authority chains, it cannot be defended. And here are the 5 elements every Un-Sueable file must contain. Number 1, time-stamped decision logs. Every action recorded with date, time, and decision maker identity. Number 2, multi-party approval chains, PR authorization, attorney review, and agent documentation for every material decision. Number 3, verified vendor credentials, W-9s, current insurance certificates, and license validation before any work begins. Number 4, risk disclosure documentation. What alternatives were evaluated and why specific options were rejected. Number 5, signed concurrence records. Digital proof that all fiduciary parties approve the action before execution. And if any one of these 5 elements is missing, you do not have a defensible file. You have a liability waiting to surface when an heir gets angry. Let me show you what this looks like when it works. 3 years after a probate sale closes, an heir contacts the attorney with a complaint. Why did we spend $12,000 on a roof when my cousin said he could do it for $8,000? Without proper documentation, the attorney's forced to reconstruct decisions from memory and incomplete emails. And this takes hours of non-billable time and creates exposure if the reconstruction has gaps. With an Un-Sueable file, the response takes 60 seconds. The attorney pulls the RFB documentation package you provided. They show 3 contractor bids with verified credentials. Risk assessment noting the cousin had no insurance and 2 prior mechanics liens. The personal representative's signed selection approving the $12,000 contractor. The challenge dies instantly. No depositions, no reconstruction, no exposure. Just 60 seconds of documentation that ends the dispute. This level of documentation does not happen by accident. It happens because the system forces the structure. When you identify a property issue that requires estate expenditure, you do not send a text asking, "What should we do?" You initiate a professional RFB, a request for bids. This is not the informal 3 phone calls most agents make. This is a documented fiduciary protocol that creates the audit trail we just discussed. The system requires proper definition with impact assessment, 3 vetted vendor options with pricing, verification documentation for each vendor. You cannot proceed to the next phase until the multi-party approval chain is complete. And this is not bureaucracy. This is fiduciary protection. Every decision creates a permanent record that defends the attorney years after you've moved on to other deals. Right now, pull up your last probate file. If an heir challenged your contractor selection in court tomorrow morning, could you produce the 5 elements of defensibility in under 60 seconds? If you're reaching for old emails, you do not have an Un-Sueable file. You have a liability that has not surfaced yet. Tomorrow at 8 a.m. Pacific, day 5, the automation architecture. I'll show you how the platform executes RFB protocol without adding 3 hours of admin work per case. Subscribe so you do not miss it. The complete 5 elements checklist and RFB templates are in the operator briefing link below. Wheels up, 8 a.m. I'll see you in the briefing.